2 days later, they start to limit recreational activities, which still allowed people to go on their beaches. And then immediately after that, they closed all beaches, including private beaches, and made it a criminal offense. So the plaintiffs in this case immediately sued, and this included, of course, people who were just on their own property, whether they were alone or with others far away, it didn't matter. Luckily, this did expire in 1 month, so it only lasted 1 month. And after that, the county did reopen all of their beaches.
Yeah, but that's a long month if you're stuck inside. You can't go anywhere, and the height of the pandemic, and you've got a beach of your own you could go at least relax on. That's a long month.
And it's April. I mean, the beaches must have been lovely that time of year. This is Walton County. It's kind of near Pensacola, right up the northern part of Florida.
Yes, it would have been literally the ideal time to do exactly that, social distance and spend time on your own beach.
During COVID, a county in Florida banned property owners from accessing beaches that they owned. Was that a taking? Turns out it was. We'll discuss that case from the 11th Circuit. Plus, the 5th Circuit ruminates on the nature of law itself. All this week here on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Thursday, December 4th, 2025, and I am joined by two of my colleagues to discuss these cases from the 11th Circuit and the 5th Circuit. One of them, Diana Simpson, will be on in a moment to discuss this case from Texas, which has
Mississippi.
Mississippi. It's not a very big circuit, only 3 states. But yeah, the other side of the circuit, Mississippi. But the important thing is there's a concurrence, kind of run-of-the-mill case, but there's a concurrence which goes into all kinds of stuff, which we'll be discussing. And then after that, the 11th Circuit and beaches and takings. We're now going to Mississippi. Sorry, Mississippians. The 5th Circuit is bigger than just Texas. The shout out to Louisiana as well. So this is a case that, like, the majority opinion, I don't think we'd normally have on Short Circuit. It's about
I would call
arbitration.
It a snooze fest.
Well, we did have the super funny case about arbitration that our friend Rafi Cohen discussed back on our live show for our 10th anniversary. But that was because of this like insane stuff about arbitrators fighting each other, essentially almost with knives. But this case is instead kind of more standard. But then it kind of really takes this wild left turn when we get to the concurrence. So Dana, tell us the story.
Yeah, so just starting with the snooze fest part of it, and with no offense to the litigants, because of course cases are very important to the people litigating them. It's just we like to talk about the extra spicy stuff here, right? And I'm not sure that the majority qualifies as that. But just to give you a kind
Short Circuit is for spicy.
Yes. We can trademark that. So Mr. Stanford was living in a rehab facility. He flicked a lighter near an oxygen tank, and this started a big fire, and he was terribly burned. So his conservator/guardian filed a federal lawsuit under diversity, and the nursing facility moved to compel arbitration, saying that when Stanford's brother kind of checked him into the facility, he signed this admittance paperwork that included an arbitration agreement. And so Mr. Stanford did not legally designate a health surrogate. His brother was acting in this capacity. And so the question is whether Stanford's brother could properly sign that paperwork and bind Mr. Stanford to arbitration. And so the Mississippi statute on the question says that in this circumstance, when there's no surrogate who has been designated, family members can act as a surrogate in descending order of priority. So first your spouse, then your adult child, then your parent, and then an adult sibling. And so Stanford argued that his son would have been proper and should have taken priority over his brother. So the son would be in the second category that they listed, and his brother's in the fourth. And so the existence of his son as a person able to do this precluded his brother from being able to do it. The nursing facility said, no, that's not right. Both the son and the brother can serve, and the priority only knocks in and matters if there's a disagreement that arises between multiple or among multiple surrogates, I guess. So the statute is totally silent, and this interpretation is determinative of the case. So the Fifth Circuit says, all right, we'll just ask the Mississippi Supreme Court to address this. Fine, easy peasy. Really not a whole lot going on. It's like, I think, a 6 or 7 page opinion, and most of it's talking about the facts and then laying out the statute with the descending order of priority. And Judge Oldham is not a fan.
And huge revision before you go into his opinion, Dinah. I kept calling it concurrence. Of course, it's not a concurrence. It's a dissent.
That's
so
true.
I maybe I was thinking of the Villarreal case where he did a concurrence. But anyway, dissenting Judge Oldham.
He is not a fan of certification. So he starts by saying that it barely existed before the Supreme Court issued a decision called Clay in 1960, and now it's extremely overused. So as an aside, before I get into the substance of his opinion, he is a fan of road mapping, and I want to talk about this because this is a thing that matters in legal writing very much, because it gives the reader an understanding of what's coming and where they can turn very quickly. This is something that is drilled into us as writers at IJ, and Judge Oldham's opinion really does a trick. And so the last paragraph of his intro starts with, "This dissent proceeds in 4 parts," followed by a brief description of each section, and then the sections each have a brief roadmap of their own subsections.
It's very law review-y.
Chef's kiss. It's really it's a reader's friendly, like, little handhold as you work through this opinion that really it goes through a lot of stuff. So he starts, as one might expect, with history. And so at our founding, diversity was almost the entirety of inferior federal courts' jurisdiction. So the Anti-Federalists didn't want to do this. They said, look, state courts are fine. Federal cases are heard in state courts all the time. Federal claims are heard in state courts all the time. And, we don't need these inferior federal courts deciding these diversity cases. Like, the state courts can handle it.
And maybe tell non-lawyers what a diversity case is.
My apologies. So in the Judiciary Act of 1789, the first Congress established this diversity jurisdiction theory that with cases where the dispute is over $500 and includes citizens of different states on either side of the V. So if one plaintiff lives in Louisiana and one plaintiff and one defendant lives in Texas, and the amount is in excess of $500 at the time, it's since been increased, then you have what's called a diversity case, and you can file it in federal court. And the idea is that, this is disputed, but the idea is that you get out of this kind of out-of-state bias that you might otherwise face, and just kind of get into a more neutral area to have this dispute. So, federal courts, like I said, at the founding, their business consisted of these state law diversity claims, and then you had the federal claims in state courts, which seems somewhat opposite. But everything was fine, and it wasn't until 1875 that Congress gave federal courts this general federal question jurisdiction, which I didn't realize it came that late. That was a fun new fact that I learned in this case.
Yeah, it kind of tied in with the Civil Rights Act in 1983 and all that. But that was Civil War, right? But
and a good time to introduce federal courts to disputes.
Yes, there were some reasons for that, but we got along with just diversity in federal courts for the most part, for lower federal courts for a long time.
Yeah. And so Judge Oldham then kind of examines this historical premise behind diversity jurisdiction and says that, this traditional view of this concern about out-of-state bias isn't actually true. And the evidence shows, and he relies on this, I think, Duke Law Review article about this that examines the evidence of it to say that actually out-of-state bias is rare and isolated, and the concern was more about protecting creditors from these state laws that would pop up that would favor debtors. So that's an interesting little factoid to go down. But then he starts looking at the federal court's practice. And so from the founding until the 1930s, federal diversity cases were adjudicated according to this distinction between local law and general law. And local law, these are written laws and long-established customs. For local laws, federal courts deferred to state courts because they represented particularly persuasive evidence of what the rules of local law were. These were people who kind of were steeped in it. But the general law was not attached to any particular sovereign, and it just existed by common law, and there was a consent among a number of sovereigns. And so there's no deference to state courts with this general law because state and federal judges were equally capable of deciphering it. And then came Erie, which was written by Justice Brandeis, and this collapsed the distinction between local and general law, and then announced broadly there is no federal general common law. And under Erie, state high courts are now the final arbiter of state law. And a fun side note that doesn't come from this comes from other research I've done. The same day that Erie came out, the Supreme Court also issued a case called Hinderleiter that held that apportioning an interstate stream must be done according to the federal common law. This decision was also written by Justice Brandeis. So in one day, you have two opinions coming out, one kind of dispensing of the notion of federal common law, and one saying, "Oh yeah, it's still helpful in this circumstance." So, who knows?
For more on Erie, we have a Bound by Oath episode from a few years ago that we'll put a link in the show notes if y'all are interested.
Check it out. Erie is a fascinating, big shift, big seismic shift in federal courts and state courts, and so Erie presents these kind of a series of practical problems. And so what do you do when state law is unclear? And so one option is abstention, which Judge Oldham might have won me over on this point because abstention is a scourge of litigants, and it's something that we deal with at IJ. When federal courts have jurisdiction, the case should be properly in front of them, and they say, well, why don't we just let the state figure it out? Well, there's a very good reason that we brought this case in federal court, and it should be adjudicated. We're properly here, and you're just getting out of it from a made-up theory about why you should abstain and let the state courts handle it. And so he kind of marches through the different types of abstention: Pullman and Burford and Louisiana Power and Younger and Colorado River. And not to put too fine a point on it, abstention is awful. Like, it's a really unpleasant thing to have to deal with, and it eliminates litigants from being able to quickly obtain relief that they are otherwise entitled to. That they have.
You wrote a cert petition on abstention.
I've written several. Unfortunately, that one wasn't granted, but maybe my next one will be. We'll see. And so abstention stands in tension with this foundational principle that federal courts have jurisdiction and are required to decide cases that fall within it. And often they use these balancing tests that are totally unworkable. They're basically an abdication of judicial duty, and it just delays and delays and delays. And delay isn't good for litigants. It's not good for the courts. It's not good for anybody. But that's where we are. And so another kind of what do you do when the state law is unclear? This is where certified questions emerged from a case called Clay at the Supreme Court in 1960. So Florida was the first to statutorily authorize a certified question procedure where they say, okay, federal courts, you can give us a call. This is like your phone a friend, if you want to go back to mid-2000s game shows. Phone a friend, and we will explain to you what the Florida law on this point means. And so in the Clay case, this existed, and the Fifth Circuit didn't use it, and the Supreme Court said, no. You need to go back and call Florida, ask them what their perspective is. They did it. It remanded. They went back and did it. And this added years and years to the litigation, as they always do. And then after this, certification exploded. By 2020, 49 states, which is to say all but North Carolina, had authorized courts to answer certified questions, and every federal circuit uses it. Now, they all use it a little bit differently. There's different standards in each circuit. Some allow inferior federal courts to use it. Some only go off of the appellate courts. And so it's just different everywhere.
And I think the Georgia Supreme Court refuses to answer them because it doesn't believe in Erie. But it's the only example of that I know of.
So I guess Georgia might have a statute, but they don't listen to it. And so he then talks about kind of these theoretical problems with modern certification procedure. It inverts the history and the tradition of federal courts. It's a poor substitute for reckoning with the power federal courts hold over the states. It's difficult to reconcile with fundamental obligation of federal courts to decide these cases. And on and on and on. He also raises a host of Article 3 questions, which are interesting to consider. And as I said, it's procedurally irregular because there's no clear test. Different courts use it in different ways, and that it depends. Different panels use it in different ways, and so you're kind of at the mercy of whichever panel you end up drawing. And ultimately, it fails to deliver its one practical promise of efficiency. It adds a lot of time, it adds a lot of expense to the parties, and not everybody can afford that. And so he concedes that exceptional circumstances might warrant certification if it actually avoids a substantial question of federal constitutional law, or it's going to avoid the serious disruption of by federal courts of kind of the state government. And so he then kind of circles back to the Fifth Circuit's use of certification generally, the test that it has, which is standardless, as he calls it, a standardless standard. And applying it here shows the problem with the whole enterprise, as he says. There's no constitutional question involved. There's no interference with Mississippi sovereignty. No one has requested certification. This is just a thing that the court does to punt. And adding it and doing it here is going to add significant delay to the case. And so you're going to go back and say, okay, maybe you're supposed to arbitrate, maybe you're supposed to be in federal court, and now it's 4 years later, and okay. And so he says, ultimately, we should treat Stanford's invocation of federal jurisdiction with the respect it deserves by exercising that jurisdiction. And so it's a really interesting case. I don't think I'd ever thought that much about certification. It's something that I've contemplated using in my cases when I'm in, I had one case that was filed in state court. The government removed it to federal court, and there's an open question of state law, and so we've talked about whether we should certify, and I think sometimes the answer is yes, sometimes the answer is no, but that's something we consider. And then when a court does it sua sponte, you're kind of taking that out of the party's hands. And as you see here, in a case where there isn't a constitutional question, there aren't these like big heady problems that you might be trying to avoid. It's in some ways a run-of-the-mill case. And is that a good use of time and resources?
Right.
Anyway, I thought it was really interesting. I had never given this much thought to it. Clearly, Judge Oldham has thought very much about it. He cites a talk that he gave at one point with transcripts or audio sites, and I found that really interesting.
Yeah. Well, and I talk a little bit about that talk that he gave in a moment. But Anne, curious as to your thoughts if you've ever had a situation where you think, should we certify this to the state Supreme Court, or that would add a year to the case, so maybe that's a bad idea. What do you think?
Yeah, I definitely am. Being newer just in my career in general, haven't had the chance to really deal with those types of questions yet. But just a couple of points that Diana touched on that I thought were really convincing that Judge Oldham made is, the fact that neither party could bring it up. And the court itself was they felt that they were equipped to make that decision. And then for the Supreme Court to reverse and say, no, you should have certified, I feel like it's just really overstepping, especially if the court felt like they were able to make that call. And also, it creates some really weird incentives if the only way to get a question in front of a state Supreme Court is to try to go the federal route and hope that they certify. That just seems a huge waste of time and a crazy procedural loophole.
If the state doesn't provide a mechanism to get at, to say no thank you, it's interesting because most states have this discretionary review procedure to get up to the high court, and if the high court's not interested in your question, they're not going to take the case. And so if the statute doesn't give them that escape hatch, are they forced to hear or to decide an issue without it having been kind of on a full record the way that the court might otherwise like? That's an interesting point.
Yeah, and it's do you really want that court to be hearing your case that you've sort of almost forced upon them? I know judges don't take kindly to that. And even though I know this whole thing is focused on the question of certification, I know that I've been hearing, I haven't dealt with it yet, but any sort of abstention is the bane of every IJer's existence, just as a procedural pitfall that I've heard of. And so I'm kind of curious on your guys' thoughts about whether overturning Erie would really solve this. I know that's a big question, but like, is that really a route to, lessen the issues that come with abstention?
So I think yes and no. I mean, the Erie subject is a real big one that we can talk a bit more about. But my understanding of the pre-Erie world, like Diana was saying, was there was local law and general law, but some of that is shorthand for a lot of it was like a state statute or the interpretation of a state statute or regulations such as they existed back then. There would be more deference to the state courts than, a really classic common law question, like an Erie, like a tort claim that's just under the common law, or a contract claim. So a lot of these abstention doctrines are younger, maybe a different thing, but a lot of them, like Colorado River or Pullman, they're about like weird quirks and state statutory schemes where I could see federal courts still trying to pass the buck in that case, even under whatever was before Erie. Diana, does that line up with your understanding?
I think so. It's so hard to consider a universe without Erie that like I don't even know what that would look like. I'd be perfectly fine reining in lots of abstention doctrines, that's for sure. I think they're overused. Younger is the classic example of just this like amoeba that grows and overtakes everything, right? Because it was originally about a man who was and there's a bound by oath about this one too. It was originally about a man who was facing criminal charges, and in the middle of that prosecution, he files a federal constitutional case, and the court's like, no, you need to take care of that one. And so now it's expanded out of you have active criminal proceedings going against you to, okay, well, it also applies to admin proceedings. It also applies to civil stuff. It applies, across the gamut. Even if you file your federal case first, you still might get youngered out if the state does something in the interim before the federal court has done anything.
And I mean, younger extension isn't really about not knowing what the law is. It's just about deferring under our federalism, as they call it,
right,
to the state, criminal apparatus or administrative apparatus. So I don't even know if that applies.
No, I mean, I use it as an example because of just of the creep, right?
But I think maybe it goes against Judge Oldham's argument to some extent. Like younger extension would probably be around if we got rid of Erie and nothing else changed.
Yeah, but abstention's bad, and I want to agree with him on that point. And I'm going to use my younger example for it.
So one thing that really I think is going on here is tying into that speech that Judge Oldham gave. And Judge Oldham has made a few waves recently with different news, but here's just to take two of them to tie together. So he gave this talk not long ago about not having circuit court 3-judge panels be binding precedent for the same circuit court. And so what are the horizontal stare decisis or whatever. And that's because of this idea that I have talked about in short circuit in the past when it's come up. But many people have discussed this idea, and it's kind of the old idea that court decisions are not the law themselves. They are evidence of the law. So, right, judges announce the law. They do not make the law. Which some people would call legal fiction, but right, it's a good legal fiction is the argument. And so when courts are stating their decisions, they're not like writing statutes so it's not law in the same way. And so that is kind of dovetails with what he's saying here, that under the pre-Erie, that was like the pre-Erie idea about law in federal courts. Like, we're doing law, state courts are doing law. Sometimes we'll disagree, but it's all just the same law, and courts are going to disagree about what the law is, and what we say is just evidence of the law is. And he says here, page 16 of the slip opinion, And this is key. Federal courts deferred to state courts on questions of unwritten local law, not because those courts created the relevant rules, but because their opinions represented particularly persuasive, even decisive evidence of what those rules were. But then the evidence for the general law, was not, you wouldn't defer to the local courts. And so then it's just whatever the state and federal courts are saying is evidence of this general law. A few people recently have kind of said more about getting rid of Erie. My old co-author Todd Zwicky has railed against it for years. More recently, Steve Sachs has written at Harvard, has written about getting rid of Erie. Will Bode has written with him. And so I think Judge Oldham's kind of picking up on some of that. And probably that's never going to happen. And so we're left with, what do you do about certification in an Erie world? And I don't know if there's an easy answer. Like I read recently, the Supreme Court of Texas spends a considerable amount of its docket on answering certified questions from the Fifth Circuit. And it seems like they're maybe getting a little tired of it. And is the answer to just be like the Georgia Supreme Court and not answer any and just, let federal courts figure it out?
Or they could have a mechanism to kind of turn down the tap a little bit and say, we'll accept them if we decide to, and take half of them, or to only take the interesting ones, or only take the ones that they think they have particular Texas expertise on, that, whatever. There's certainly things they could do to limit their involvement. And so I don't know what the statute looks like in Texas, whether it's a statute or whether it's a rule of appellate procedure or something like that. But there are ways they could change it so they just didn't have to take all of them.
Yeah, I think you're right. I think it's kind of a cooperative federalism thing where, some states take them, but they turn down a lot.
Yeah.
And so maybe some of these state Supreme Courts need to do that more, and then that would discipline the circuits to not do it as much, because the circuits vary. But yeah, I don't think the Supreme Court is going to figure this all out with because these cases never get to the Supreme Court anyway. So it's not like they're going to be able to fix it. Congress could fix it, but that doesn't happen. So thank you. That this has been a nice little gallop through the nature of law. And now, instead, we're going to go to the beach. So Anne has told me she's never been to a Florida beach. So maybe this is like the kind of the first step, and then in the future you'll get to do a vacation down there. But unfortunately, these property owners couldn't go to the beach either, even though they owned the beach, which I had not. I got to say, there was a lot of crazy stuff that happened during the pandemic. We all heard about it, right? Sitting at home, just nothing to do, reading the news. I didn't remember this. This is insane. They own their own beach, and they couldn't just go sit on their own with, no microbes passing by on their own beach.
Yes, I thought this was a perfect case for me to discuss during the holidays time because, first of all, I do wish that I was on the beach, and I plan to cure that very soon. But, I also like to live right now with a holiday cheer under the delusion that courts can and do uphold constitutional rights, especially in the face of outrageous facts like these. So, yes, this is another COVID-era case where the government was going berserk with their emergency powers. It's a case in Florida. And it started with the governor, and his first executive order was pretty tame. It just said, please limit all, try not to go to the beach that often and do social distancing. Pretty tame. And then just 2 days later, he decided to close all public beaches. Again, okay, not terrible. Although if you did go on the beach, you'd be subject to a criminal offense. And the county attorney specifically stated at this time, as if he was foreshadowing, he knew that the board did not have authority to keep any beachfront property owners from their private property. Despite that, 2 days later, they start to limit recreational activities, which still allowed people to go on their beaches. And then immediately after that, they closed all beaches, including private beaches, and made it a criminal offense. So the plaintiffs in this case immediately sued. There are a variety of property owners. Their entire property was considered beach. It's a very vague definition that's part of the the county's code. It basically said the sandy part next to water. It was a little bit more. It was a little bit
So if the
better than
dunes
that,
go,
but
just hundreds of yards back, that's all beach.
yep, it's all beach. And like I said, this kept some property owners away from their property completely, and some property owners only from a small portion of their property. They immediately filed for a preliminary injunction, but that was denied because the district court found that the state likely had the power to implement these emergency regulations. But the actual enforcement is where it starts to get a little bit crazy here. Instead of just generally saying that, they actually sent police officers out. Police officers were either camped out, patrolling and looking for anyone trying to access their own beach, or, actually just using it as like a driveway and just using it to look for potential beach goers. And anyone that they caught, they would say, you better leave now or else I'm going to take you downtown. And this included, of course, people who were just on their own property, whether they were alone or with others far away, it didn't matter. Luckily, this did expire in 1 month, so it only lasted 1 month. And after that, the county did reopen all of their beaches.
Yeah, but that's a long month if you're stuck inside. You can't go anywhere, and the height of the pandemic, and you've got a beach of your own you could go at least relax on. That's a long month.
And it's
Yes.
April. I mean, the beaches must have been lovely that time of year. This is Walton County. It's kind of near Pensacola, right up the northern part of Florida.
Yes, it would have been literally the ideal time to do exactly that, social distance and spend time on your own beach. Moving on to the legal claims, the plaintiffs brought a host of claims, Fourth Amendment, 14th Amendment, both state and federal claims, but the 11th Circuit really focused only on the state constitutional claim related to privacy, and then, of course, the takings claim. Before I move on to that, the district court, when they when they dismissed all of plaintiffs' claims initially, they said this is just a use restriction. It's not physical or regulatory taking because all of the property owners can still sell their property. This is temporary. You can still use part of your property, or at least some of the plaintiffs could, and you still have the power to exclude others. So that was their reasoning behind that. Now, moving on, the 11th Circuit first discussed the Florida constitutional claim related to the privacy rights. And it was a mootness 3-factor test to determine if the county's stopping enforcement and their voluntary cessation, whether that was the 3 factors are deliberate or manipulating jurisdiction, meaning did they do this just to avoid the lawsuit to moot it, or were they actually trying to stop enforcement? Was this permanent and complete, or were they just going to go back and do this later? And lastly, whether they maintained the commitment to the new policy, or, like I said, they were just going to, enforce this later on. So they found that all 3 factors were in favor of the county, therefore making it moot, and they affirmed dismissal of the prospective claims for the plaintiffs. Moving on to the physical taking, they found that the county's enforcement violated the plaintiff's right to possess, use, and exclude their properties, which is basically every stick in your bundle of property rights. They went on to discuss the distinction between physical and regulatory takings and use many, many examples, but they mostly relied on Cedar Point to show that this is definitely a physical taking because the police were there on the property. The plaintiffs could not go on their property or risk arrest, and some plaintiffs were not able to go on any part of their property at all. So that really just constitutes a physical taking. And they ended it with a great quote. I thought, there's no COVID exception to the takings clause. So just because it's COVID time does not mean that you lose all of your constitutional rights, especially not your property rights. They did go through and sort of reject each of the district court's reasonings as to why it's just a use restriction and not a taking. And one important point that I thought they made was just that the duration, it doesn't matter if it's a temporary taking, the duration only impacts the just compensation part of the analysis and not whether or not it's a taking. Obviously, this is a great precedent and gives us it's really great for them to enforce constitutional rights in this way. So I don't mean to complain, but I guess my only question that came out of this was when I went in, I thought it was pretty obvious what constituted a physical and a regulatory taking. But I felt that their explanation was a little bit confusing and ended up jumbling up the two for me a little bit. So they have this quote. It's not too long, so I don't want to read, I don't want to read a whole portion of it. But just this quote alone is what I felt really confused me. This is their distinguishing point between physical and regulatory taking. They say whether the government has physically taken property for itself or someone else by whatever means, or has instead instead restricted a property owner's ability to use his own property. Now, based off that, I didn't feel like they were wrong that it was not a physical taking, but somehow I felt like it was both a physical taking and a regulatory taking, because they agree that although this was a regulation that restricted the property owner's use, it was physical, and I agree with that. But is it not still a regulation that restricted their use? So I guess now I'm unsure exactly what constitutes just a regulatory taking and not a physical taking. And then their other example, relying heavily on Cedar Point, was obviously also a physical taking. So I would love to hear your guys' thoughts on the case in general and on whether you could enlighten me on that distinction a little bit better than the 11th Circuit. But again, not to complain, a great opinion.
Dana, let's turn to you for enlightenment.
There's I know it when I see it, doctrine of constitutional law, which I think pervades a lot of different things. And so I am not a takings expert. But the fact that the attorneys for the government and the district judge said that there's no taking when the government comes in and says, you have your property and you may not use it for anything. That's just wild to me that multiple attorneys would agree on that exact point, that that's not a taking. And so even if it's limited in time, even if there's an end point, the violation still exists. And so, of course, that'll impact the kind of relief to which you're entitled, right? A taking forever as opposed to a taking for 30 days. But say someone came in and rented the house, and the whole point of renting the house was because they wanted to sit on a beach. They needed their vitamin D while the world was going crazy. And they specifically paid that money so that they could access the beach, and then all of a sudden they're told they can't. Well, then they've been shorted money. And so it's not a perfect analogy, obviously, because we're talking about renting and your expectations with that. But it's the idea is that you're not getting what you're supposed to be getting, and the government is the one telling you can't have it because of reasons. And so, whatever the reasons may be, you still have to pay for it. Whether you can say, okay, well, this is justifiable or reasonable or whatever. I mean, we're 5.5 years out from the initiation of COVID. This is only now getting a decision that this was a taking. They tried to get a PI, didn't succeed, and the mootness issue arose. And it's how long is it going to take for judges to say, yeah, the Constitution means what it says, and the government can't just take your property and not let you use it without having to pay you for it.
Well, agreeing with everything that Diana said, I'll say that Ann's question is the $64,000 question, which doesn't sound like that much anymore, but we'll go with it, of takings law that has been unanswered, but maybe answered to. I think this county it would be a wild and crazy mistake if they petitioned for cert on this case, but
hopefully they do.
Yeah, hopefully they do, right? Because what is this case, I don't know about these particular judges, but in general, this case would not come out this way, in my opinion, before Cedar Point Nursery, the case that Pacific Legal Foundation did that came out just a couple years ago, and that you mentioned a few times, Ann. So that case, right, is about these union organizers who come on your property just every now and then under this California statute, and so the bottom line is that that's a taking, even though it's just temporary, because it is physically on the property. Well, before that, though, there was Tahoe Sierra. So Tahoe Sierra is this case from 2002 where there was a temporary moratorium on, I remember the exact facts, but building basically around Lake Tahoe. And the court said that under that kind of temporary prevention of the use, which is, building a house or whatever, that is analyzed under the Penn Central standard. So that's the real flexible regulatory taking standard, but not a complete taking like you might have under an actual, like a real physical taking, or the Lucas standard, which is the other part of takings law where you can't develop, or the property goes to zero, basically, which is not true in this case, of course. So under Tahoe Sierra, it seems like, well, this is temporary. The use is, going to the beach. You still own the property. You can still start. So I could easily see judges going with it being Penn Central, and then you do the whole Penn Central thing, and you go pandemic, and then you lose. So, but Cedar Point is kind of like, it's a whole different way of looking at takings law in some ways. So now it's like, is it Penn Central, Tahoe Sierra? Is it Cedar Point? Like, what is even going on here, man? And these judges went in that direction. I could still see, a set of judges going in the other direction even after Cedar Point, but Cedar Point is kind of on point. What really didn't help was that the cops were like themselves going on the beach, which they were only doing to enforce that very law. Like if they hadn't gone on the beach to enforce that, it seems like this provision, and the court just kind of assumes they have the right to do that. I'm kind of like, well, I guess it's an open field because it's a beach, but anyway, that's a whole nother thing. So if they hadn't gone on the beach, I don't know if this case comes out the same way, even though that really wasn't material to the people accessing their property.
That was one of the factors the court relied on. I think it's a big factor, and it's also like totally bananas, right? Like the whole point of this ordinance was to theoretically protect people from this airborne virus, which we discover later, like being outside is actually the best thing to do. And so you have police who are decreasing the space between people from different households going and saying, you must get inside so you don't catch this disease that I could very well be bringing on my lips as I speak to you. That is bananas.
The whole time was bananas, of course.
It was.
This was particularly bananas. And what did you think about that? The aspect of the cops actually going on the beach being part of the taking.
Yeah, I think that's a really good point because I'm sure that there are a host of other regulations that were enacted in various parts of the country we never heard about that were probably just as crazy, but didn't have not rogue, but just random police officers out enforcing it to this crazy extent. So I feel like that is what really pushed it over the top, even if we all agree that that would have been a taking regardless.
Yeah. Well, it's 5.5 years later. We are still having cases to do with the pandemic here on Short Circuit. I'm sure this will not be the last one. It seems like there's far fewer than there were a while ago, but it is.
Hey, they're really good. I mean, they're establishing limitations on what government can do. And so from the perspective of a small L libertarian who litigates for liberty, that's a good thing, right? Like the North Carolina Supreme Court issued a resounding decision in favor of liberty because of these COVID cases. So if we want to keep litigating them and keep saying government can't do wacko stuff, great. I'm on board.
Well, yeah, and it seems like we get further away, judges get more emboldened to say things like, wow, that's wacko stuff. And it's unconstitutional. Well, stay tuned until our next episode for more wacko stuff. But thank you both for coming on. Please follow their case in Albuquerque, Diana and Ann's, and please go check out our links in the show notes if you're interested in diving deeper into these questions. But until next time, please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.